Can you close that door, please?
Right.
The glare. Ready? Here we go. Everybody's ready? Yvonne, is everyone ready? Thank you all very much. Good day. Thank you for coming again. Yesterday, I told you I would do another press briefing today on matters with respect to the turbulence in the public domain. I have several items I want to address, but they all flow from what has been a major catastrophe. I termed it yesterday an atomic bomb with a nuclear meltdown. Everything comes from that. With respect to the actions of highest officers of our state, the President, the Prime Minister, the Attorney General, and those persons at the Police Service Commission and elsewhere. So I want to speak to you today about 5 issues, all of which flow from the entanglement of these various offices. The first item has to do with a motion that we have filed in the Parliament. Before I share that motion with you, I want to say thank you for joining us. We are in unprecedented times. For the first time in our nation's history, we have no substantive Commissioner of Police. We have no acting Commissioner of Police. But the meltdown goes even further. Based on the rulings yesterday, we have no substantive Deputy Commissioner of Police, and we have no acting Commissioners of Police. Can I please? So we have nobody in the top ranks of the police service. Yesterday we thought it was only with respect to say Gary gone and Jacob gone. So with respect to the 2 actors, they were gone. But the justice made a ruling late in the night, and I'll come back to that, changing her order, which now means we have none of these positions. No substantive Commissioner of Police. Can I please disturb this mic? It's too far away from me. I have to come quite here on the side when I should stand in the middle. Okay. Thank you so much. Thank you. No substantive Commissioner of Police. No acting Commissioner of Police. No substantive Deputy Commissioner of Police. And no acting Deputy Commissioner of Police. This is unprecedented in our history. Totally something that has never happened before. So we have those who are to protect and serve, the TTPS, are totally rudderless, leaderless, headless. Yesterday's ruling by Justice Kangaloo, where she ruled that the appointment of Mr. Gary Griffith as acting police commissioner was unconstitutional, and her ruling that DCP Jacob's appointment was also unconstitutional, has serious repercussions for the TTPS and for the fabric of our very democracy. As a nation, we are a nation of laws. No one in our republic is above the law, whether it be the Prime Minister, whether it be the opposition leader, whether it be the President, Her Excellency. We all must uphold the law and dignity of our respective offices. And we are all accountable to the actions of our actions. We are accountable to the people of Trinidad and Tobago. Due to those in the highest offices showing utter disdain and disregard for the laws of our land, we are now in a very dangerous predicament where crime, murders, and lawlessness continue unabated. In fact, increasing. One editorial headline today was Rise in Crime, serious crimes. And at this point, we have no official leadership at the main agency responsible to protect and serve. We face 2 states of emergency now. The one baselessly imposed by government in the name of the pandemic, and now one created by the highest office holders of our land due to total disrespect for our Constitution and for upholding and carrying out their constitutional duties. For those of you listening, in the past weeks, the opposition has been questioning and demanding answers on the state of the PSC, Police Service Commission, and appointments being made. We have been raising questions on many other issues in the public domain. When we come to the High Court ruling from yesterday, it is apt that I begin where the learned judge ended. At the last paragraph in the judgment, it reads, "The court concludes with the answer to its initial question posed through the lyrical genius that was Lord Austin. Who will guard the guards?" This is a quote. "Who will guard the guards?" And the judge answered from the quote from Lord Austin, "We, the people, through our elected representatives." Another former Chief Justice said once, a very famous quotation, I'm sure most people know it, "Justice must not only be done, but must also be seen to be done." I say that the opposition, which I lead, the elected representatives of the Parliament, of the people, will be those guards. I gave a commitment that I will use all my powers legally and under the Constitution, all powers available, to hold those in office accountable. With the support of my 18 elected MPs in the House of Rep, I have filed a motion in Parliament pursuant to Section 36 of the Constitution for the establishment of a tribunal to investigate the removal of Her Excellency Paula May Weeks, ORTT, as President of the Republic of Trinidad and Tobago. I have a copy of the motion here which we'll share with you, and it is signed by myself and all our 18 MPs. In some jurisdictions, they call it an impeachment motion, but that is not what is said in our Constitution. Under Sections 35 and 36, this is a process I have employed to make the office of the President accountable to the people of Trinidad and Tobago. The motion is grounded on several facts, and those are set out in the Constitution. The motion has been filed pursuant to Section 36 of the Constitution, and the grounds are set out. There are only specific ways that you can seek to have a president removed from office. And those grounds are set out. 1, or A, that the president has behaved in such a way as to bring her office into hatred, ridicule, or contempt. That the president has willfully violated the Constitution, and that the president has endangered the safety and security of a nation, of the state. So those are grounds, and there's another one, but I don't think we've reached there yet. Another ground could be by reason of mental capacity and so on. At the rate some are going, some of us will reach there sooner than later, but that ground, we have not triggered that ground. We're using the other 3 grounds. So we are saying that Her Excellency, the office of the President, has behaved in such a way to bring the office into hatred, ridicule, or contempt by interfering and or facilitating interference with the Police Service Commission, and by proceeding in the circumstances to appoint new members of that commission, willfully violated the provisions of the Constitution, securing independence of that commission in the performance of its functions, and violated Section 123 of the Constitution, which is a duty that when you get a merit list, you don't hold on to it. There is a constitutional duty to send the merit list to the Parliament. The court ruled very clearly, because that was not done, those appointments were unconstitutional. The President failed and or neglected and or omitted to carry out that constitutional duty. And the other one I said behaves in such a way that endangers the security of the state, and I'll come to that as we go along. Further, has otherwise failed and or neglected to execute her duties under the Constitution. As I say, this is an unprecedented move. No such procedure has ever been triggered in the history of Trinidad and Tobago. It is my view now that the motion is warranted with regard to all the circumstances in the public domain. The office of the President sits at the very top of our constitutional structure. Sits at the top. It's a pyramid, and she sits at the top of that pyramid in our constitutional structure. That office was created in 1976. Before that, as you know, we had a Governor General as the head of state. It was created in 1976 by the Republican Constitution. We placed a citizen chosen by the Parliament to be the head of state. That office, and indeed the person occupying it, was supposed to embody our collective pride as a nation, our collective hopes for a society described in the preamble of our Constitution, in which there is fairness, equal opportunity, most of all, a society based on the rule of law, where no one is above the law and the law is applied equally. The office of President was meant to be independent and above the political fray, well away from the politics. Why? So that it would have the legitimacy and the trust and credibility to make crucial appointments to independent institutions, such as one being, example, the Police Service Commission, but indeed all the commissions. Those independent institutions are only as independent as the persons who are appointed to sit on them. They are critical checks and balances to control the abuse of executive or governmental power. A president, therefore, must embody the independence that the role seeks to promote by its appointments and decisions made in the deliberate judgment of the office holder. As president, a president is the embodiment of constitutional authority. By extension, must promote the very values of the Constitution, such as the independence of the service commissions. And may I pause here? A vital part of our Constitution is what is known as the separation of powers. You have the legislature, you have the executive. That separation of powers has been breached in my respectful view. And I know yesterday somebody asked me, has the President acted unlawfully? And I said, well, she has no moral or legal authority at this time given all the shenanigans. But I will go further. There has been a breach of the separation of powers in terms of the actions, conduct of these high office holders, including the President. So, for the authority given to the President at the top of our constitutional structure, the Constitution also gives to the office of the President certain legal immunities necessary for the performance of their duties. But then the question arises, so who is the President accountable to? We as a nation were not fortunate. We were fortunate that we never had reason to reflect on to whom is the President accountable, because this issue never arose. The issue never arose. But sadly, it has arisen, in my respectful view, at this time, in these circumstances. The Constitution itself, then, provides the answer to the question, to whom is the President accountable? A President is elected by the members of the combined houses of the Parliament, Senate and the House of Reps. And likewise, proceedings to remove a President must be started by at least 2/3 of the vote of a combined House and Senate. So it is fair to say that the President is accountable to the Parliament. There is no other remedy, there is no other pathway, no other way to hold the President accountable. The Constitution gives us the Section 35 and 36 as the avenue, or as the tool or the vehicle to seek to have a President removed from office. The burning question is, would the Parliament, MPs and senators, including the independents, hold the President to account? The only way to hold a President accountable is by a motion for her removal to the Parliament. When that motion is filed, as we filed it yesterday, when that motion is filed, the next step is that the Speaker must convene a joint sitting of the Parliament. So all senators and all MPs will sit, the motion will be debated. If the motion is passed, then you go to the next step under the Constitution, where a tribunal is set up to investigate. And after they have investigated, they will send their report back to the Parliament, and again it will be the Parliament to consider the findings in the report to make a decision, remove or not to remove. So it is a process. We have initiated this process. And you may tell me, Kamala, you know they outweigh you. They have the numbers. You're going to lose. But I think in the interest and in the public interest, we must have accountability, and we'll raise the questions, and they will have provide answers in the Parliament. Who went to the President's house, for example? When? In the dead of night? When? Why? Why? Why did that happen? Who was it who interfered in what was supposed to be an independent process? Why? One question to be answered, and there'll be others, of course, in the course of the debate. So, Kamala, you're going to lose with the votes. But it is my duty as the opposition leader with my team to use the mechanisms available in the Constitution to hold the President to account. You cannot go and lock up. You cannot ill-speak her. Even in the Parliament, there's a rule you cannot ill-speak the President and some other officers too, unless it is on a substantive motion. And this is what this motion is. And it is stronger than any other motion on our standing orders. We have privileged motions. We have private motions. This one is a constitutional motion because the Constitution itself gives us a provision in Section 35 and Section 36. So, I want you to understand, this is the only mechanism. No number of editorials, no number of commentators, no amount of public pressure can substitute for this constitutional process, where all the facts can be raised in debate in the Parliament, and the truth will come out. The opposition has a duty to move this motion. This complicit government will not, and the members of the public, you cannot. This is a duty that has to be placed on the shoulders of the loyal opposition of Trinidad and Tobago. And you know, when this debate takes place, I will call for the whips to be raised, to be removed, so that each member in that debate, the senators and the House of Representatives, MPs, that they can vote according to their conscience. So the whip, I will ask in the debate when we begin it, that the whip be removed. I did that once when we had the issue of the death penalty, I believe. We had a matter before the Parliament when I was Prime Minister with respect to being better able to implement the death penalty. And I lifted the whip and gave my MPs the opportunity to vote according to their conscience. And I think this is one that I'll ask the government, that their whip also be lifted so that people can vote according to their conscience. The matter is one of utmost public interest for the public good. When the motion is debated then, we will have the opportunity to demonstrate that we stand for public accountability, due process, and the rule of law. In the event the motion is defeated, we would have a president who would have been open to scrutiny in the eyes of the public. If we don't do this, there is no other way that we can expose or raise or bring forth the activities, the conduct and so on that have transpired. I hope that we can embark upon this constitutional process designed to uncover the truth and to hold those responsible to account. So some of the things that an investigation could reveal, should the motion be passed and the tribunal is set up, it will reveal to the country the burning questions, the answers to burning questions so far remaining unanswered. The President, the Prime Minister, the Attorney General, the Acting DP, the Director of Public Admin, Mr. Harrison, sent an affidavit to the court which seemed to have been, by the way, leaving out certain parts, saying certain parts, which leads us to believe that there was a list, a merit list, for the substantive police officer that was never taken, commissioner, never taken to the Parliament. These persons and others must be summoned as witnesses before the tribunal to provide answers for what has happened. The collapse of the Police Service Commission, and the collapse, of course, I think, of the democracy, and the fracturing of the TTPS. It will also reveal who was the public official who met with the President on the 12th of August at President's House, and who interfered in the process of delivering the list of nominees to the President with respect to the Commissioner of Police. It will clear up the vaguely drafted affidavit of the Acting Director of Personal Admin, Mr. Corey Harrison, which stated that the list of nominees for the position of Commissioner, substantive Commissioner, that list of nominees was given to Her Excellency, the President, on the 12th of August. He said they completed the exercise on the 9th of August, and that list, for merit list for a substantive officer, was given to the President. Lo and behold, we've learned afterwards, I said it, some magic wand, some magician came, went and interfered at the President's house, and that morphed into something for acting rather than substantive commissioner. They will have to explain about the person persons who met at the President's house on 12 August, and why the President refused to send a notification to the Parliament about the list of candidates nominated by the PSC for Commissioner of Police. With respect to the acting list or merit list for the Commissioner of Police, the controversy surrounding whether there's a merit list for the appointment of a substantive of the main man or the acting person, that can be cleared up as well. We have confirmation from former PSC member Mr. Kewal Singh, that there was a substantive merit list for the post of Commissioner of Police. How did we reach to a merit list for an acting person? How? Why? My question then too is, where is the merit list for the main post, not the acting? The reports are there was this list. It was interfered with. It's hiding in somebody's desk drawer, I hope, and they will bring it out of that desk into the light, out of that drawer into the light. It's a serious matter. And what is the legal status of the merit list? I was asked that question yesterday, and I said that it will die and it cannot rise up like Lazarus. But that was before the judge changed her order. In the night, again, I'll tell you more of what went on in that court yesterday and last night. First, the judge had ruled that the entire 2021 order was unconstitutional, null and void. That was said in the open court. We have to await a transcript because you're not allowed to record like you can here now. You can't record inside here in the courthouse. We have to await the transcript, but I am reliably informed by attorneys who were present and by those who viewed the proceedings. You could zoom in, you could go on the link, that the judge ruled the 2021 order unconstitutional. The whole thing. So when you asked me, I said, well, okay, anything done pursuant to that order would be dead. Can't raise up again. But in the night last night, I don't know if it was the middle of the night, but sometime last night, it changed. Another wand was waved, another magician appeared, and that morphed into saving the order, the 21 order, 2021, but removing only clause 4. So the rest of it is saved. But clause 4 is interesting, because clause 4 is the one which says that a contract person can be appointed as a police commissioner or a deputy commissioner. That clause went. And when that clause went, we have issues now with Jacob and the status of Jacob. She ruled the 2009 order unconstitutional. She took out Jacob. Sorry, the Honorable Judge took out Jacob, but he was taken out by virtue of that ruling. So, what is the legal status of the merit list? That will come forward too. We haven't changed the original first order that the whole 2021 legal notice was unconstitutional, to confining it only to the clause 4. What it means is that anything done under that order to provide a merit list, the merit list will stand. It is saved. So we had where the whole list was pelted out, the whole order was thrown out, and then by magic, as I say, some magician, some wizard attended and waved a wand, and the whole order. I saw Mr. Farris making, it was a minor amendment. This is a major amendment, you know. So the judge made a minor amendment, saving the whole legal notice and only taking out one paragraph. You calling it a minor amendment? Judge first ruled that the whole notice was wrong, the order. And then you come in the night, and I'll say more about that in a minute. So what are some of the consequences which flow from what transpired in the court yesterday? I was speaking here about the motion we've brought, and we will prosecute that motion in the Parliament and outside the Parliament with respect to the removal of Her Excellency from the office of the President. And I gave you those grounds, and we'll share with you a copy of the motion in a little while. The second thing now I want to go to is with respect to what's happening in the courthouse now. What happened in that court? So you have the highest offices of our land, President, Prime Minister, Attorney General, embroiled in all kinds of, in Trinidad what they say, kankalang or kankalang, word to that effect. These high offices And now I have to question whether the judiciary is not also getting embroiled in these things. Whether there's interference with the judiciary, you have to ask that when I give you the sequence of events from the court ruling, and permit me to do it properly here because I have to give you the timelines and the dates. I want to register first our deep concern over the fact that the court revised its orders after the court received an email correspondence. So I told you one thing said in court, they revised it later in the night. Afterward, they got emails from the lawyers for the Attorney General, lawyers for the Police Service Commission, a dead Police Service Commission. You remember that collapsed? You have lawyers representing, there was a joke with Mr. Gerald Ramdeen some years ago when they accused him of representing a dead man in court. That he had a client had passed away, and they accused him wrongfully or truthfully. You cannot represent something that is dead. But we had lawyers yesterday, and since the commission collapsed, representing a client who no longer existed, did not exist in law. So those lawyers for the AG, lawyers for that Police Service Commission, sent emails to the judge, to the court. I am not impugning any improper motives, but I'm raising questions. So I say it's to the court. Of course, to the judge. It goes to the judge when it goes to the court, to the GSO. And this was done in the absence of natural justice, in the absence of due process of law. They sent these things, and Mr. Faris and his lawyers, the state and their lawyers, never gave an opportunity to the claimant to make any submissions. So they sent their submissions to the court after the judgment, but never gave the claimant and his lawyers an opportunity to be heard. You've heard that many times. No natural justice. And the judge revises her order with the claimant never being heard on these new matters with respect to the orders. Clear violation of the rights of due process and natural justice. No judge, it is my respectful view, should ever revise an order that you pronounce in open court based on the correspondence from one of the parties or the other parties. So you shouldn't do that. You should give an opportunity. If something arises, suddenly that might have been oversight. Yes, the courts can revise their judgment, but both sides must be heard. You can't take one people's side and go. It doesn't work that way. On Monday, 11th October, after all parties made their oral submissions in the matter, the court fixed yesterday, Thursday, 14th October 21, to deliver its judgment, and the court gave an assurance that a copy of the judgment would be immediately available by email to all parties after it was delivered in open court. So deliver in open court and then send out email to all parties. On 14th October, this is what happened. That's yesterday. So the court gave that assurance, and this is what happened. On 14th October, the court read its judgment, but indicated that it was not in a position to send out the email immediately, as promised, as was promised before to the parties, because the court wanted to do a spell check. Again, we have to get the transcript, We must get that transcript. Court wanted to do a spell check. That's what they told the parties when they had the court had completed reading the judgment. Queen's Counsel Anna Ramlogan told the court that its order would have significant legal consequence and implications, and hence he urged the court to at least immediately deliver its order with the subsequent provision to give a full written judgment. It's okay? So he said, okay, this is so important and everybody's waiting on this. At least give just the orders, your rulings, and then you can send the full written judgment by email. That's okay, fine. At 4:42 p.m., the court emailed the perfected order, just the order. The court, having taken time to carefully consider the wording of its order, issued a formal order of the court, signed by the following declaration, and I quote, "It is declared that the Commissioner of Police and Deputy Commissioner of Police Selection Process Order 2021 is unconstitutional and void, being contrary to or ultra vires the provisions of Section 123 of the Constitution. Okay? This is a perfected order. So first you had it set in court. 2021 order, dead. Null and void. Unconstitutional. So the court invalidated the entire legal order. 2021 order. This meant that procedures spelled out for commissioner and deputy commissioner was null and void, no legal effect. It was for this reason yesterday I said that the entire selection process would now have to be scrapped, whatever had gone before, because the court said the whole order gone. The fruit from a poison tree is a poison fruit. The poison tree being that the order was bad, unconstitutional, so the fruit is also bad. Anything that was done pursuant to that order would be poison fruit. Now, when we got the perfected order, signed and stamped by the registrar, the claimant, Mr. Ravi Balgo bin Maraj, and his legal team, assumed the matter had been completed. Of course, they went home to get some rest. You know, people have to rest sometimes. It's after working hours, you got the order from the court, you got the oral judgment, then you got the order itself, but not the full judgment. Okay, they're going home to get some rest. Lo and behold, this morning, it emerged that the court, in response to emails from the AG and his lawyers, and from the non-existent police commission, their lawyers, revised this order. Faris called it, as I said, a minor amendment. It is a major amendment. It's like you knock me down completely. I mean, I'm dead. And then you come on, you just take out one finger. It's not a minor amendment. It's not a minor amendment, AG. Don't fool people. Don't try to fool the public. It is not it's a major, major amendment which has serious consequences for the TTPS and for the country as a whole. So this morning now, we learned that the new order amended, which now, as I said before, only invalidates the clause 4, section 4, if you will, part 4 of that 2021 order. So the whole order being dead, you have now revived the order with the exception of the clause 4. Again, serious consequences as a result of that. And this is what the aforementioned declaration was suddenly modified to read, and I'm reading it here now. This is a changed ruling of the court. It is declared that paragraph 4 of the 2021 order is superfluous. I take issue with that, and I'll tell you why in a minute. It's superfluous and hereby struck out in light of the provisions of section 123.2 of the Constitution, 123.2 to 5. Struck out. Because why? It's superfluous. But there was a very important part in that paragraph 4 of the order, and that had to do with allowing a person on contract who had previously served on contract to be appointed as an acting commissioner. It allowed contract officers. You have now removed any contract officer from being able to act in the post. So, Mr. Jacob, sorry, I'm told you're on contract too. That's what I'm told. So Jacob got slapped up on two sides. First, he got slapped up that the order 2009 was bad in law, so he gone anyhow. But then for future, for prospective going forward, you remove contract officer, but you remove Gary too. So he was previously on contract, he's gone too, by changing that order in that way. So we move along. This is incredible. This is shocking that the court would have revised this order without inviting, as I say, the other parties, the claimant, the man who brought the case, the man who won the case, Ravi Balgo bin Maraj, to give them the benefit to respond. They did not even, no one even bothered to call them, to put them on notice that the orders were being revised or being considered to be revised in favor of the claimant, to be revised in this major way. The judge had noted at paragraph 1 of a written judgment, and I quote, "This claim before the court is one of great constitutional and general public importance. Changing the orders," end of quote, "changing the orders made by the court in such a politically sensitive matter," this is an exceedingly political sensitive matter, "is not something that should be lightly undertaken, and certainly it should not ever be done without the court having the benefit of the claimant, Mr. Ravi Balgobin Maharaj, of having the benefit of responses from his lawyers, their submissions on the matter. His claim succeeded and prompted the grant of the very relief that was being changed. He succeeded. And then you amend it in a major manner. This, in circumstances where the AG saw it fit to issue a press release, so it wasn't good enough the lawyers sent these emails, The AG issued a press release. Listen to this. Late yesterday afternoon, before the judge had the opportunity to reconsider. So emails going left, right, and center. But the man issues a press release saying as follows. He indicated, that is the AG, that invalidating the entire 2021 order was made in error. He puts that press release. Judge hasn't given her a second revised order. Was made in error. Who made the error? I remember the Prime Minister said what happened with this Police Service Commission and so on, and the appointment of a commission. When Mr. Nelson gave his advice, he said a mistake was made. Well, again, the question is, who made the mistake? Who made the mistake? So when the AG is saying it was made in error, how can you say the judge made that in error? That is for the judge to say. But the judge hasn't said that. As I say, she has given us two versions of the ruling. So he says further, the AG says, invalidating the entire 21 order was made in error. We will therefore be appealing that aspect of her order in any event. Why are you threatening? Is this to intimidate the judge? The goodly judge has not yet given you her final version. You email and have your people emailing and harassing. And before that could be done, what did you do? You say you're going on appeal. Was that a threat of intimidation? Again, is that an interference? I'm raising the issue again. Is that an interference in some manner with the judiciary? The AG also made public the fact that he intends to appeal the order, striking out paragraph 4 of the order. So two sets of appeal. One, the whole order. The second, he wanted to strike out the paragraph 4. Guess what? That's exactly what happened. He intends to appeal the strikeout of paragraph 4. Isn't that what I just said? That's what happened. That's where the amendment, the change, that's how the order was changed to do exactly what this man was threatening to appeal about. That can't be right. It just cannot be right. This press release was a clear attempt to save face and do damage control. He showered himself, which he does very often, he showered praise on himself, saying the court accepted his legal team's submissions, as the nation would forget this arrogant and pompous behavior when he rubbished this case. When the case was first came forward, you know what he said in an interview 2nd September? He rubbished Mr. Balgobin's case, And now he's just saying he win the case. Boy, Faris, the day you win a case, I think I might have a take a trip out to go to space or something. I'll have to do something very different. Showering himself with praise, he said, Al-Rawi rejected Persaud's views, telling Newsday he is wrong, saying he, meaning Faris, had drafted the order. The AG said, I can say quite respectfully that I disagree with Mr. Persaud's view. This is when this public person in the public domain said something is wrong with that order. Something is wrong. And the AG said, no man, I drafted that. Everything is fine. It's perfect. And now wanted to boast he won the case. As dishonest as you can become. So, I will wrap up on this point. But I find it shocking that the judge's order was changed after these emails and so on went out. And what may appear to seem to some threats of intimidation or harassment. Continuing with the events of yesterday, at 8:05 p.m., an email was received from the court office which attached a revised order from the court. The email contained no message but simply an attachment which, when you look at it closely, revealed that it was the amended order. So this is at 8:05 p.m., the amended order. There was no indication in the mail that the order had been revised. So you just get the second one now. Remember I told you we got one earlier? The lawyers got one earlier. The second one, it does say it was a revised order. At 11:13 p.m., just before midnight, the witching hour, the court emailed its written judgment. The judgment appears to be consistent with the revised amended order as requested by the Attorney General. And this is the sequence of events. Unfortunately, as I say, people are not allowed to tape or record in the court, the virtual hearing, and the official transcript is still not available to verify whether the orders pronounced in open court are the same as that in the amended version, and clearly they are not. So that will give us the evidence that the order has been substantially changed. In these circumstances, I want to convey our great disappointment and concern. Mr. Maraj, his lawyers were entitled to be heard by the court before they changed the order. It was foreseeable that the mail sent by the AG and the lawyers for the Police Service Commission after working hours may not have been seen by the claimant's team until this morning. If the learned judge considered it sufficiently urgent to change her order, a phone call would have sufficed. Call one of the attorneys for Mr. Maraj and indicate, look, we're looking at this order to revise it, give me your submissions. It is very unfortunate this was not done. Amending the order in the dead of night, after the AG issues his press release, which seemed to be threatened to file an appeal, but not see, they did say he will appeal, would create an impression that the court capitulated to his demands on a case of such great political sensitivity. Given Mr. Maraj's early complaint, you remember Mr. Maraj, the claimant, had filed something in the court asking this judge to recuse herself from the case. Why? Saying you have a family relationship with one Christine Kangaroo, who is the President of the Senate, who was a former PNM MP. She has a family relation. Please recuse herself. And one would have thought the court would be far more circumspect in dealing with this very serious, politically sensitive matter. I also note, whilst the court also acknowledged delay in dealing with other politically sensitive cases. Now remember, when the claimant and lawyers asked to recuse herself for one, this family relationship, two, you have politically sensitive judgments outstanding for years. And despite repeated calls for these cases to be for the judgments to be handed down, they have not been handed down. Some of these cases involve the Prime Minister. The outstanding ones that have not been dealt with involve the Minister of Finance. It involves the former governor of the Central Bank. The court acknowledged, yes, I have delayed, but never gave those matters to stand in abeyance, never gave any indication as to how long again you have to wait for these judgments to come forward. The superior courts have repeatedly emphasized the need for judges to observe the principles of procedural fairness, which mandated the court to ensure that you hear all the parties. Hear all the parties. So there was a clear breach of natural justice when the court amended that order. In the circumstances, I want to urgently request a copy. I've asked my staff to get a copy of the court transcript of the hearing on Thursday, when the court delivered the oral judgment. We also seek an explanation as to how and why the court revised and amended the order, again without the opportunity to be heard from the other side. I have noted that the Honourable Chief Justice personally logged on to the hearing yesterday, and I can only hope that where necessary, that the Honourable Chief Justice will intervene to prevent a miscarriage of justice and to dispel the public perception that the judge amended her order in the dead of night as a knee-jerk reaction to the AG's letters. Political interference in the judiciary cannot and must not be tolerated, and the UNC will not stand idly by whilst our supporters are treated in such unfair manners, unfair ways, to save government face and its incompetent AG. I condemn what has transpired, and of course more to come on that. I've just told you what we do with the President's conduct. We will tell you more about what will happen in terms of what transpired with the judiciary, the court. Consequences then of the judgment, of the ruling. I said it before. We have none of these substantive posts: Commissioner of Police, Deputy Commissioners of Police. We have what has transpired here now. I am told that Mr. Jacob, when appointed as DCP, that his notification was brought before the Parliament. On March 12th, notification for Mr. Donald was dated 11 March 2021. That came to the Parliament. On March 12th, it was laid in the Parliament. So notification 1, 11 March, dated 12 March, laid on the order paper of the House of Parliament. Then, on April 30th, Mr. Jacob, on April 9th, the motion to approve Mr. Jacob was debated and passed in the Parliament. So he went through the proper constitutional process for him to be brought before to be approved by the Parliament. And thereafter, on the 30th April, Mr. Jacob got his letter of appointment, but then he was given a contract. He was given a contract, and I spoke to you about contracts before. Now, what happens now? Mr. Jacob has gone. The question is why? Why did you do all of this? Why did you come and move and get the order changed to take out contract officers from the plea? Why? So we know you want Gary Griffin gone, but now it looks as though you want Mr. Jacob gone too. Why? The question is why? There are two other DCPs. Earl Christopher, who is DCP Operations, Joan Archie, DCP Admin, and of course Mr. Jacob, who was DCP Investigations. With all these DCPs gone now, and I've told you Mr. Jacob is gone, well, Madam Christopher and Madam Archie, they also gone. Why? Because their notifications never came to Parliament and was never approved by the Parliament. And the court ruling here says that these things must come to Parliament, must be approved by Parliament. So they are gone too. So who is heading the police service? All the top officers are gone. Who is looking after the role and function filled by Earl Christopher, who was DCP Operations? Who is looking after the roles and functions of DCP Archie, who is dealing with admin? Who is dealing with at that level the investigations, which was led by DCP Jacob? This is, I can't even find a word. It is astounding. This is the first time in our history. It is also frightening given the state of crime in our country at this time. But there is another very serious matter to ask about. If all these appointments were invalid, unconstitutional, what about the actions taken by these various office holders when they were acting in those positions or when they held those positions? What happens, for example, if they receive payments at the higher rate because these are higher positions? What happens? Do they have to pay it back to the government? What happens for persons who have been arrested and charged under the health regulations? What happens to them? You know what's going to happen? You will get a flurry, a plethora of cases against the state where they will allege that their things have been unconstitutional because the person holding the office did not have the authority. DCP Jacob did not have the authority because unconstitutional. He didn't have the authority to sign the regulations, man. He didn't have that authority. What are you going to do? So we are going to get a whole host of cases coming for any actions taken. Now in the civil jurisdiction, yesterday I mentioned something called the de facto officer. The de facto, yes, fine, I'll have some water. De facto officer. In the common law jurisdictions, in the rule of the common law, I'm sorry to be talking so much law, but it is what it is. You have this de facto officer, put it in a glass please. You have the de facto officer who would remain. So even though you are unconstitutionally appointed, whatever actions you did and things happen, fine, you could get away and you can be validated. But when you come to the criminal jurisdiction, it is not a simple matter. And that's why I say people charged, persons charged and so on. It's a serious matter. They will now have an avenue to go to court and say you have unconstitutional office, you've done unconstitutional things, blah, 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 blah. We'll get all those cases. I'm saying it's a common law doctrine, the de facto officer, to allow where things like this happen for people to, without going to court or without going to the legislature, to say, okay, let that go. All these 11 years of appointments and so on, under the bad 2009 order, leave them. Leave it like that, thank you. And but you see, our jurisdiction, we have a constitution. And that common law doctrine, while it comes into our law, because of our constitution, the constitution trumps the common law. And where it is, you're not just saying these offices, well, something went wrong, whatever. This is where the constitutionally, you were illegally appointed. And where it is, the Constitution says this, as the judge ruled yesterday, then you're going to have to examine each one of these matters on a case-by-case basis. So whilst you have de facto officer, you have exceptions in the criminal jurisdiction and per case by case. So expect another flood of cases coming to the court, and we have none other to blame than this government and its incompetent Attorney General. I move along now on the issue of, one second. I move along on a last issue, which has to do, again, with this incompetent Attorney General. Mr. Hines said yesterday, reported today, that DCP Jacob will continue to head the police service. But he can't. As I just explained to you, DCP Jacob is gone. In two ways, he's gone as the acting DCP, acting commissioner because of the 2009, whatever I told you before, invalidating of 2009 order, gone. And now he's a contract officer, gone again. Pointed out to you, there's no DCP. No DCP. So Mr. Hines, Mr. Jacob cannot head this. I replied to you, you're wrong. They always told me you were the kind of lawyer who used to do fish market cases. I believe it now. I believe it now, fish market cases. Because you're so totally wrong. DCP Jacob is gone. He may be there in a different capacity. I'm not sure of that, but he cannot head the police service. So therefore, who is going to head the police service? And Prime Minister, you were very wrong, you know. When you told us that whoever sergeanting will continue to sergeant, even though we don't have a commissioner of police, whoever sergeanting will continue sergeant, and whoever inspecting will continue to expect. You know, remember, it's very frivolous kind of when he was asked for, should this situation that we now find ourselves in, should that arise? He was asked that in a press conference a week ago. He said, I don't worry that. But you're very wrong. Because there are functions that a commissioner of police has, or his acting person, that cannot be carried out by anybody else. Must be a commissioner or an acting commissioner. And just quickly, I will tell you, can you bring me the shortened version, Shoshana, of the functions of the Commissioner of Police? And I'll get back to that in a moment. I'll move along with the final point, which has to do with the Faris again. So I'll come back to just list for you quickly functions that nobody else could fill in the circumstances we find ourselves. I wrote to the TTPS, and at that time was the acting Commissioner of Police. At that point, he was still in seat. But the letter will be there with the TTPS on the 1st of October 2021, calling for an investigation into the failure of Mr. Faris Alwari to transfer motor vehicle registration number PCY84 to Mr. Roger Kewal Singh, and the failure to notify the Transport Commissioner of the change in ownership contrary to Section 19 of the Motor Vehicles and Road Traffic Act, Chapter 4850. I have not received a response to date. So this letter is dated 1st October. Today is the 15th of October. No response to date. But I have received information, and I'm asking if this is true, that police, some officers did go down to the Transport Commissioner's office. Did go, but not for the purpose of investigating. I am told that they went in an attempt to cover up, to ask for this matter to be covered up. And I'm told that the person was a man of integrity and he refused to do it. So I call upon TTPS to tell us if this is true, if that you went down to the licensing office to have the records tampered with. Because up to as we speak, there is no certified copy in the name of Mr. Gable Singh. We had raised all these issues before. But it is frightening. Again, when you have a rudderless, leaderless body, you can have a private army, members comprising a private army doing the bidding of the PNM. Again, a very frightening situation. Somebody sent me an email. You did very well in your press conference yesterday. Thanks for explaining and so much. But I don't care if there's a commissioner of police, I don't care. We're hungry. We're hungry. I totally agree. There are many people suffering. Failure of the government to really give the relief and so on. I agree with that. But do not fret yourself and think this thing is not important. That you don't care if there's a commissioner or deputy commissioner. That is a pure fallacy. Because this will impact on every citizen. You can have rogue police officers turning up at your door because they wear a yellow shirt. You can have rogue officers turning up at your door because they took part in a protest. A guy told me, the guys who were protesting in Barrackpore recently, he said the next day, as he driving out on the road, he got a ticket because he was in the protest. People tell me from Barrackpore that the police are coming to their homes and demanding to get CCTV footage of the protest so that they can arrest people and do so on. This doesn't touch and concern you. It concerns everybody. And of course it concerns the democracy. We must not allow them to escape with these things. We must not allow the government, we must not allow the president to not be accountable and to get away that all this has happened. Who will guard the guards? Who will guard it? Is you, the people. You, the people, will have to take that mantle. You will have to take up that right. Because it will trickle down and the dictatorship will come first. They came for X. Remember that famous thing from the Nazi Jews? Nazis and the Jews. First they came for you. No one spoke out. Then they came for you. Nobody spoke out. And when they finally came for you, yourself, there was no one left to speak out. We must not go down that road into that kind of dictatorship. We must not allow that to happen. So friends, we have now taken the only constitutional step that we can take, which is to take the motion to the Parliament. And I will share with you all the things that we'll just give it to them. The summary of the functions of a Commissioner of Police or Deputy Acting Commissioner of Police, which cannot be carried out by any other office. So the TTPS cannot function effectively or as efficiently as it should. So as I close, I say thank you very much. We will continue to do our duty as the loyal opposition of Trinidad and Tobago. We will hold these officers to account. And I say again, the President must resign. The Prime Minister must go. Faris must go too. And the entire government must go at this time for all the mess that we've been put into. I thank you all very much. How long was that? 1 hour?